Singapore. My name is Kevin Nash. I'm the Deputy Registrar and Center Director of the Singapore International Arbitration Center. On behalf of everyone at SIAC, I would like to welcome you all to the latest installment in SIAC's International Arbitration webinar series. This one is the second part of the dialogue with the SIAC Secretariat titled Dialogue on COVID-19, Commencement of Arbitration and Pre-Constitution Applications. We are very pleased today to have my colleagues and members of the SIAC Secretariat, all international arbitration specialists and institutional experts. Many of you may have seen the open letter from the President of the SIAC Court, Mr. Gary Bourne. We have now instituted a live chat function on the SIAC website. So if you have any questions on SIAC's processes and procedures, you can now go to the SIAC website and be connected to one of the arbitration lawyers at SIAC. And this is really how this webinar is meant to function. It's meant to give you an inside look at our processes, and particularly in light of the COVID-19 pandemic. So because of this aim of interactivity, we would encourage you to ask questions as we go. We will leave time at the end, but please do submit your questions as they arise when we deal with the specific topics. Before proceeding to the introductions of our panelists, there's a few housekeeping matters. This is a 75-minute session, so if you're collecting CPD points, please do stay for the entirety of the session, and please do let us know how we're doing and provide feedback on this session. I will start with my colleague and SIAC counsel, Alona Bitskeviaya. Alona is one of the longest tenured members of the SIAC Secretariat. Prior to joining SIAC, she worked for a global financial services provider and completed internships at law firms in Europe and Asia. Alona is New York qualified, fluent in English, Russian, and Lithuania, and is a big part of our efforts to attract Russian disputes to Singapore and SIAC. Of course, Alona is very able to administer disputes conducted entirely in Russian. Next is Piyush Prasad. He's an Indian lawyer who studied at the National Law School in India, is qualified in India and pending admission in New York. He was a senior associate, one of the leading law firms in India. He's represented clients in practice in arbitrations and litigations, and he completed his Master's of Law at the University of Chicago, where he was Vice President of the International Law Society. Chahat Chawla is also an Indian qualified lawyer who has a first class from Christ University in Bangalore. He also has a master's degree in international arbitration and dispute resolution from the National University of Singapore. Prior to joining SIAC, he was a senior associate at one of India's top tier law firms and worked on in practice arbitration and litigation. Jordi De La Torre Anglada holds a BA in economics and a Juris Doctor from Georgetown University Law Center in Washington, D.C. He is also admitted to the New York Bar. Prior to joining SIAC, he clerked at the U.S. Court of Appeals for the Ninth Circuit and was an associate at the corporate department of a top U.S. firm in New York City and Madrid. Jordi is fluent in Spanish, English, and Catalan, and he is leading SIAC's efforts in Spain and Latin America. Of course, I give that introduction, but I'm sure that you all know these institutional representatives very well, and please do check their profiles on the SIAC website. So we've designed this to be practical and specific, so let's start at the beginning in the chronology of an arbitration. And Piyush, I would like to start with you to discuss the commencement of arbitration. The commencement of arbitration generally, and also in the light of the COVID-19 pandemic. What should a claimant bear in mind when they're commencing arbitrations, or even more simply, how do you commence an arbitration at SIAC?
Thanks, Kevin. It's a pleasure to be joining everybody on the webinar. Commencement, of course, is a significant step in the arbitration process. I mean, not only it signifies parties' real conflict between the parties, the dispute has come to fore, and it's also important from a perspective of limitation. So that's one aspect of commencement. Now, if we move to this SIAC rules about how to commence and what comprises a proper commencement. Now, if you look at the UNCITRAL Article 21, and that provides that unless otherwise agreed by the parties, the arbitral proceedings commence on the date when the request for arbitration is received by the respondent. Now, if you look at the SIAC Rule 3.3, which provides that the receipt of the complete notice by the registrar shall be deemed to be the date of the commencement. So the parties, by adopting the SIAC rules, have agreed that commencement will be the date of receipt of the complete notice by the registrar. Now, what has changed today, and yes, I mean, what was the situation before COVID? parties have to bear in mind that under the SIAC rules also, you have to effect service on the respondent, which is provided under Rule 3.4, and also notify the registrar about the specifying the mode and the date of the service. So that's one thing that's important. I would like to also talk about what is that mode of service on the respondent. Again, Article 3 of the UNCITRAL rules talks about, it does not talk about specifically about electronic mode of communication. However, this is subject to the parties' agreement. So under Rule 2.1 of the SIAC rules, any communication can be made by electronic means. So this is again an important aspect that parties should bear in mind, because everywhere it has become difficult for courier services to reach. So subject to the notice requirements in the arbitration agreement or the agreement of the parties, parties can, by way of under the SIAC rules, make service by electronic means. In terms of the notice of arbitration under Rule 3.1, I mean, now, because of electronic communications, we request the parties to specify in the notice any and all email addresses that they may have of the parties concerned. And a second thing that I would like to also mention is about the case filing fee. A notice is incomplete without the case filing fee. And now there are difficulties in filing checks, but of course, parties can make payments by bank transfer under the to SIAC, which remains accessible to everyone.
Yeah, Piyush, if I could just jump in, I think you raised some interesting points there. First of all, in terms of it being the party's obligation to effect service, but also if there's any deficiencies in the notice where you could effectively end up with multiple dates of commencement. You have commencement under the model law, where you have the date of receipt of the notice, and then you have commencement under the SIAC rules, where it's a date of receipt of the complete notice. As we always underscore, that's why you want to make sure all the requirements under Rule 3.1, and in particular, the filing fee, have been paid. One interesting feature of the SIAC rules is that you do have this term substantial compliance. So you've administered many hundreds of cases. What have you seen in terms of substantial compliance? What is that really meant to guard against?
Of course, so notice requirements are important because that's one of the limited grounds under the New York Convention for setting aside of an arbitral award. So we are, of course, cognizant that a party should be given notice of the commencement of the proceedings. So in terms of the substantial compliance, we, like, for example, parties, wherever possible, are required to submit the arbitration agreement along with the notice of arbitration. Sometimes we see big agreements which contain the arbitration clause come in, or we've seen sometimes only the extract of the arbitration agreement which is provided to us and as part of the notice. So we would ask if there is any deficiency under Rule 3.1, we'll go back to the party and ask them to comply with the requirements, and then the registrar will take a call as to whether there has been substantial compliance, and only after that, SIAC will notify the parties of the commencement of the arbitration under Rule 3.3.
Right. Let's lock in on the payment of that filing fee. We just had a question from one of the attendees. So payment, of course, can be made by bank transfer, also by local check. In light of the COVID-19 situation, does SIAC also accept payment, say, by credit card payment?
So that's an interesting question because we generally discourage parties from making payments through credit card because of various logistical issues and other considerations. But on a case-to-case basis, parties may pay through credit card. In fact, that reminds me of a story that an Indian advocate told me. It was a Friday evening, and that was the last day of limitation, and they had to file a proper notice of arbitration. And he gave a call to SIAC in the evening, asking for this, whether payment by credit card is possible or not. And we were able to check internally and able to get back to the council in a relatively short span of time, and they could achieve and were successful in at least lodging the payment notice of arbitration with SIAC.
Yeah, and I mean, that's one of the benefits of the live chat feature. Obviously, if you're up against a limitation period, you don't want to be asking about SIAC and whether they can accept a credit card payment at 11:58 p.m. on the last day of the limitation period. So that's something that, and we often get, of course, parties prior to filing are asking about the different mechanisms for payment. So you have local check, bank transfer, and case by case, potentially payment by credit card. Okay, so that largely takes care of the claimant side of things. So as a respondent, COVID-19, movements are limited, mail is not proceeding in the same way. What is the process? What do you do as a respondent when you get a notice of arbitration? What are the considerations? What are the timelines that you have to think about?
So one common, because of COVID, one common problem that respondents are facing, of course, the notice sometimes comes with a warning, sometimes comes without a warning, and mostly it comes without a warning. So they, of course, they have to prepare their response to the notice, and for that, they may need client instructions. And if it comes without a notice, they may not be prepared for that. But under the SIAC rules, Rule 2.6 provides that the registrar has a discretion to extend or even abbreviate the timelines prescribed. So the respondents can make a request to the registrar for the extension of time by giving, whatever reasons that they have, and the registrar can make a determination if timelines need to be extended in a particular case.
I guess one thing you have to be cognizant as well is any timelines within the clause. So even if the registrar is extending the time for the response, so say because of the COVID-19 pandemic, you put forward a memorandum, you seek the views of the parties, but if you have, say, 7 days for each side to nominate an arbitrator, that's not something that SIAC can disturb. The parties are still going to be bound by their bargain. So I think parties have to be a little bit cognizant of that. What I would also say, sort of building off your point, is that we do have an estimate your fees section on the SIAC website. So you can look at the sum and dispute and see what those deposits are going to be. Because once the notice and the response are filed, then parties are going to have to pay deposits towards the estimated cost of arbitration. The quicker that can happen, the quicker that we can get this arbitration moving along, which may be particularly relevant during the COVID-19 pandemic. Okay, so let's assume that we have notice filed, response to the notice, and the response says, the respondent says that I haven't agreed to SIAC arbitration. I think that this clause does not provide for SIAC arbitration. SIAC is not competent. I didn't sign it. They want to make a jurisdictional objection. What is that possible? How does that process for jurisdictional objections, how does that work under the SIAC rules?
We do often see respondents making a jurisdictional objection, and this kind of objection will fall under Rule 28.1 of the SIAC rules. And as you mentioned, if a party objects to the existence or validity of the arbitration agreement or the competence of SIAC to administer the arbitration, and this is all, of course, pre-constitution as we are discussing in today's webinar. So that process works, it's a two-stage process where the objections are made to the registrar. The registrar would invite the other side's comments on those objections. And then the registrar will decide whether or not to refer to those objections to the SIAC court. Now so this gets divided. The registrar at the first level would review the objection and the submissions of the parties on that aspect, and then decide whether to refer the matter to the court or not. Now, what can be the possible considerations at this stage? Of course, the basis on which the objection is made is actually provided, which is, if you are objecting to the existence of the arbitration agreement or the competence. Now, the standard applicable there is that it says that if registrar determines that the court shall determine, it is on a prima facie basis. Now, before that, when the registrar is determining whether to refer or not, let's say, we will of course look at the submissions of the parties. There may be a situation where the respondent says, yes, there is no arbitration agreement and there is no SIAC arbitration, and the claimant comes back and says, yes, indeed, there is no arbitration agreement. So that actually puts an end to the matter, but that's a very, very simple and does not happen very often. We often get more complicated issues, and we get sometimes issues like the arbitration agreement has not been signed by the parties. But if the respondent comes back and says that, no, we had exchanged it through emails, etc., so that at least creates a rebuttable presumption. And that's where, we get into the prima facie standard of application at this stage. We all know what prima facie means. It's a Latin term which means at first look or at first sight. So the party with the burden of proof may only need to present enough evidence to create a rebuttable presumption that the matter asserted is true. So now, I mean, if you are able to come back and show us, yes, there were emails exchanged with the agreement, it may not have been signed. So that is something which is applicable at this stage. Then that matter would get elevated to the SIAC court. The SIAC court will make its determination on this. And I want to just highlight one more issue here, which is that any decision that the SIAC court makes, that is without prejudice to the rights of the tribunal to make a determination. And this is, of course, goes to the one of the basic principles of arbitration, which is competence, that it gives the tribunal the jurisdiction to decide on its own jurisdiction.
Yeah, this actually seems quite similar to lots of the conversations that we have in my office about jurisdiction. I think that you have particular experience with jurisdictional objections. Let me just run some quick questions by you. And of course, this is not for you to decide whether it's referred to the court, but just based on your observations, whether these kind of jurisdictional objections would typically be successful or unsuccessful. So for instance, in light of Lufthansa in Singapore, say you had a dispute between the claimant and the respondent on whether or not there was compliance with preconditions to arbitration. So there was perhaps a very general or a bit vague precondition that the parties had to negotiate. The claimant says, we did negotiate, attaches an email to show their attempts. Respondent says, no, we don't consider this good faith negotiation. Is that something that would typically be referred to the court, or are the facts in dispute? Without taking a position, of course, it's all case by case and subject to the circumstance. Is that something that you would see as being successful?
So you mean in terms of being referred to the court, Kevin?
Either one, whether referred to the court or let's keep it simple. Is that something that the court is placed to determine, generally and subject to the circumstances of a particular case?
Yeah, I mean, that's actually a common, preliminary objection that we see often in response to a notice that, pre-arbitration steps have not been complied with. But again, as you said, in de facto circumstances, the claimant said that we did try. Now, the whole question of, whether there was good faith, bad faith, how it was tried, that's something which falls under the prima facie standard, that there is a rebuttable presumption, and that's all they need to create at this stage for the SIAC court to decide. Because of course, the tribunal is better placed to determine these questions and it may not be a simple question of mere facts, but law may also be involved. So they are in a better position to make a more informed call on such questions. But yeah, of course, I mean, that's very common, and that probably will be referred to the tribunal because Yeah, that's the right analysis. And again, seeming more and more similar like conversations in my office. Let me try another one with you, where the respondent makes an objection to say that certain of the claimant's claims are outside the four corners of the arbitration agreement, and the claimant says, no, we take the view that these are covered by the arbitration agreement. This issue of scope, is that something that is readily determined at the prima facie 28.1 stage? So under the SIAC rules, Kevin, 28.1, the determination is if the SIAC court is prima facie satisfied that the arbitration should continue. So that's about it. Now, any other question, like something like this, which again is a mixed question of fact and law, and about the scope, the tribunal is again better placed to call for further evidence to determine this issue. So perhaps a better idea would be to let the tribunal decide this question rather than SIAC making a determination on these issues.
And I think it's this gatekeeping function that you have of the registrar of whether or not to refer objections to the court, I think is very useful in helping to really push SIAC's efficiency. The question is, though, if you had a non-participating respondent, and this differs across various rules, and we were looking at it because SIAC doesn't have a registration requirement, say like ICSID, what would happen if we were looking at it from a Secretariat standpoint and we thought that maybe the existence or validity of the arbitration clause was in question? Could we do it ourselves? Could we refer an objection sua sponte on our own volition to the court, or does it require an objection from the respondent?
It would require an objection from the respondent. That is my first reaction to this question.
And your first reactions continue to be correct. Let me move back to an issue of fees. We have another question from the audience, just some clarification on the filing fees. So when a claimant is filing a notice of arbitration, they email email SIAC with a notice of arbitration showing the copy has been furnished to the respondent, showing the date and mode of service, should they also include proof of remittance of the filing fee?
Oh, yes. So, of course, because as I was saying that one of the requirements for a complete notice of arbitration under Rule 3.1 is also payment of the case filing fee. And so documents is one part of it. Without the case filing fee, it is still an incomplete notice. So if you are able to tell us and submit a proof of remittance, that makes it easy. Of course, it shows you have made the payment. Secondly, and we can track the payment and apply it to the right case, because we of course have a lot of cases which are going on. That does certainly help us in managing logistics of the case. So that is a very helpful thing, and it's highly recommended that users do that.
Yeah. So Rule 3, you have all of these international arbitration specialists available that you can ask questions, and then you also have the live chat feature. So if there's any uncertainty about the process for filing the notice of arbitration, please reach out to one of these counsel or go to the live chat. Okay, we have an arbitration commenced. The arbitration, the claimant is looking perhaps to make an application for expedited procedure. Expedited procedure, of course, is one of SIAC's most popular provisions, and really one of the provisions that put SIAC on the map in terms of showing our efficiency, cost-effective, speed. Alona, expedited procedure, particularly during the time of COVID-19, what are your observations? Is this procedure even more useful now? Do you see it being deployed more than it might have been in the past?
Thank you, Kevin. As you mentioned, expedited procedure is a fast-track procedure for low-value, less complex disputes, right? But one benefit which expedited procedure gives is speed. And what we've noticed with COVID that today is more than ever, money is of an issue. So a lot of companies are concerned with cash flows. A lot of companies are concerned with financial status of the respondent in particular. So we do see a potential of expedited procedure could be used more. And if we look at the structure of the expedited procedure, the grounds under which the claimant could ask for the expedited procedure is if the parties agree, if the dispute is lower than 6 million, and in cases of exceptional urgency. And just at a quick look of the grounds, if one speaks of exceptional urgency, I can envision that COVID on the ground would create something factual matrix that would satisfy the exceptional urgency ground. Because, in my time at SIC, I think I administered about 40 expedited procedure applications, and to be honest, none of them were under the exceptional urgency ground. So it's a very rarely involved ground, which may change. Yes.
Yeah. So is most of the activity on the basis of the sum and dispute? So the case is under 6 million. And do you see most of the applications, are these contested applications? So agreement is another ground. Are most of these where the claimant, it sort of becomes that old law school joke where one side says this is a very simple dispute and the other side says it's a very complex dispute. Do you see most parties filing on the basis of that first limb?
Actually, this is exactly what happens. Usually one party says it's so simple, we can definitely wrap it up in 6 months. The other party says, no, not at all. It's the most complex dispute I've ever seen. So that's usually how it transcribes. And yes, most often the ground which is used is below 6 million, just because realistically, when the dispute arises, a chance that parties could agree, chances are very slim because parties usually do not want to talk to each other. So yes, below 6 million is the most used ground for expedited procedure.
And what about for the limb of party agreement? So if the parties have agreed in the arbitration clause, or if they have agreed post-dispute, do they still effectively have to go through a rubber stamping procedure whereby they are making an application for expedited procedure on the basis of party agreement, or does it automatically channel into the expedited procedure?
Yes, so absolutely. Even if it's under the ground of parties agreement, the parties still have to apply, and then the president of SIC is the authority who decides whether or not the expedited procedure is granted, as well as decides whether it proceeds before the sole arbitrator. So yes, in this sense, we do differ from some other institutional rules which provide for default applicability of EP.
Do you this 6 million cap, is this a hard cap? What if I'm a claimant and I have a claim and it's $6,001,001? Can I still make an application for expedited procedure?
Well, one can always make an application, but it is prescribed in the rules that it's below 6 million. And I think more importantly, what parties must understand that it's the total sum and dispute. So it's not just a claim, and it's not meaning that if there's potentially a defense which is being filed, or if there's a cross claim, we're gonna the president, when he makes the decision on expedited procedure, will look at the whole sum dispute. So in this particular scenario which you described, let's say if the claim is just below 6 million, but we do see that the respondent is filing a big counterclaim, suddenly you have a sum dispute, let's say, of 12 million, which no longer falls under the expedited procedure. And importantly, the nature of the expedited procedure must be understood. It is truly for low value, less complex disputes, because realistically, and I think this is the challenge in time of COVID as well, to take into account when one wants to apply for the expedited procedure. It's difficult enough to fit all the procedural steps within the 6-month window, because as our users would know, the award has to be issued within 6 months after the constitution of the tribunal, right, under the expedited procedure. So it's difficult enough in the times of non-COVID to actually complete all the steps, have the hearing for SIAC to scrutinize the award. So in the time of COVID disruption, the 6-month timeline could be even more difficult to fulfill. But then at the same time, we do have in our 2016 rules the tribunal's power to take the matter off EP, meaning if the tribunal finds that the matter no longer satisfies the requirements of EP. So that could be a way out of it.
We have a question that's coming in that sort of touches on what you're discussing right now. And the question is, how does SIAC ensure compliance with timelines for EP cases? Does SIAC just leave the 6-month timeline with the arbitrator, or does SIAC actively manage the case to ensure compliance?
So I think our users probably know we are very active when it comes to case management, and we do track internally the timelines, and each case manager actually would be writing to the tribunal well in advance. So usually a month before the award is due, reminding the tribunal that the timelines are running, and also reminding the tribunal that the draft has to be sent to SIAC, and the SIAC must be allowed certain time to scrutinize the award. So that's something that we keep a very close eye on.
If we were to look at your, sorry, go ahead.
No, I was just saying that, I mean, I've been taught, in the Secretariat by my colleagues, how well to use the Outlook calendar function. So the day the arbitration EP is granted, we will start, of course, keeping the milestones in mind and putting calendar invites, so just so that we are very clear, because of course, 6 months is not a long time, 180 days only. So we do that, as part of the case management, to use the calendar function effectively so that everybody is on their toes.
Piyush has been moderating so many webinars, and he's so good at it. He's taking the questions that I would like to ask. That was just what I was going to ask. I was going to ask, in addition to our online case management system, I was going to ask Alona, if we took a picture of your Outlook calendar right now, how many expedited procedure dates would you have listed there for the next few months? And I think what's important for users to realize as well is that we also have to build in time for the SIAC scrutiny, because all awards are scrutinized. So it's not as easy as just having that 6-month timeline. We also have to build in time for scrutiny, even though we're doing this in less than 2 weeks in the last couple of years. Alona, let's stay with this timeline for a bit. What are the different circumstances where the registrar extend the timeline for the rendering of the award as opposed to an application to take a case off the expedited procedure? I think this provides us with very good flexibility just based on your observations. What are the different circumstances that you might have seen?
Yes, absolutely. So first of all, it must be stated that the extension of the timeline for issuance of an award is an exception. It's definitely not a rule. And this is how the expedited procedure is structured to ensure that we have a cutoff time when the award will be issued. So from the pre-COVID time, if I may say so, I would say that it would happen very rarely, and most often there would be some very serious reasons. Sometimes it would be an arbitrator falling ill, actually, which is quite exceptional, and of course that does merit an extension. Sometimes it would be flowing from a dialogue between the tribunal and the parties, and understanding that a slight extension is required. And when everyone is on board, the registrar would also be more inclined to grant, let's say, an extension of 1 month for the issuance of the award. In the times of COVID, though, and this is why maybe an expedited procedure can become a little bit more relevant for the parties as well, because in the times of COVID, the high threshold of the exceptional extension could be more easily met. And I've seen cases in my own portfolio, which I administer, where especially let's say with the respondent, where there's a full lockdown and where the mail service is stopped and the country is just on a complete lockdown, it's impossible to proceed. So in those particular cases, there would be a granting of an extension. And addressing your question, how would that differ, let's say, that the considerations which the tribunal would have when the tribunal is taking off the appeal, or taking the case off the expedited procedure track, that would be a different evaluation. So that would be an evaluation which the tribunal would be making, and this, looking at the case and judging whether the case still falls under the expedited procedure parameters. So it's a bit of a different value judgment than the one for the extension.
Yeah, in terms of course, we always have to be cautious because we're trying to ensure the enforceability of the award, and we want to make sure the arbitral procedure was in accordance with the agreement of the parties. But I think one advantage of the ad valorem system, where you have arbitrators on capped fees, that in addition to all the proactive case management that we're doing, there is also going to be a certain taxation on an arbitrator's fees if the timeline is extended where there's not good reason. I think that what we're seeing in COVID-19, and particularly with applications to take the case off the expedited procedure, it's not because tribunals are late with the awards. It's because now that the dispute has started to crystallize, and often the parties are agreeing to take the case off expedited procedure because we may have agreed at the beginning, say it was on the basis of party agreement, but now this case has become a lot more complex. We have expert witnesses, fact witnesses. So I think that that's what we're seeing, at least in sort of my very broad observation of all of the cases. In terms
Absolutely.
of, go ahead.
Yeah, just to maybe add that this ability of the tribunal to actually take the case off the expedited track should give some security to our parties to use the expedited procedure as well, because the parties may be contemplating that they are not sure whether they will be able to complete the case within 6 months. And then, as you mentioned, the temporal dimension of the tribunal's jurisdiction could become an issue, which would lead to non-enforceability of the award. So I think the fact that the tribunal can take the matter off EP if needed should give some security for the parties.
Let's talk a little about the potential for documents only. So an important feature under the SIAC rules is that the tribunal may, in consultation with the parties, decide if the dispute is to be decided on the basis of the documents, or if a hearing is required for the examination of any witness or expert witness, as well as oral argument. How do we reconcile that with Article 24 of the model law? What are the considerations? What are the advantages? What should parties be thinking about? Shahad, I know that you had a recent case where the parties really are looking at a potential view to documents only, potentially upon the completion of certain submission stages. So Alona, if you could give us sort of very broad background on what you're seeing in your case management experience.
So yes, in terms of the broad background, as you said, under the expedited procedure, the tribunal has a discretionary power to actually proceed on documents only. And this is how it is reconciled with the Article 24 of model law, because as we would know under the Article 24 of model law, if one party requests for a hearing, the tribunal is obliged to provide a hearing. Whereas in this particular case, let's say we can run through a scenario. We have an expedited procedure, we have a claimant and a non-participating respondent, right? So in that particular case, as long as there's no objection from the party that the hearing must be held, the tribunal actually has the discretion to decide whether to proceed on documents only or to proceed with the hearing, which allows certain flexibility, especially in the times of COVID. The way, and actually I recently had a case where this is exactly what happened. So in that particular case, the parties and the tribunal realized that due to the lockdown, it just may be easier to dispense with the oral hearing altogether. But in that particular case, both the claimant and the respondent were fully participating, and both parties were actually interested to move along in the case, and it was by agreement. So the claimant and the respondent and the tribunal agreed to proceed on documents only. So quite often that's how it happens under the expedited procedure.
Chad, please go ahead.
Yeah, if I may just add, I just wanted to very briefly discuss the recent case that you just mentioned. In that case, was that at the beginning phase, because it was just at the commencement stage, the respondent wasn't completely sure whether that case was request the tribunal to insert a procedural milestone in the procedural order number 1 to essentially require the parties to report back to the tribunal after the first round of the pleadings to basically tell if they can then convert the hearing into a documents-only hearing. So this could be helpful in cases where it is difficult to assess at a very early stage whether a particular proceeding is conducive for documents-only arbitration.
Yeah, I suppose sort of looking at the hearing requirement now, and we'll be discussing with Chahat the potential for virtual hearings. I suppose that offers a fairly efficient way for hearings if one party is requesting a hearing, being able to satisfy that requirement under the model law and without adding very much cost or expense. Then you're able to have perhaps a one-day hearing or a half-day hearing virtually without adding any expense. We have another question from the audience, which is something that we see quite often, and this relates to the applications under the expedited procedure. Alona, you had mentioned, say, if a respondent has a counterclaim. So we discussed this $6 million limit. So in expedited procedure, if it must fall under $6 million, the question is, would it be an easy way out for the party objecting to expedited procedure to just artificially inflate the quantum of its counterclaim to exceed $6 million? So the claimant, let's assume, has a meritorious $4 million claim, simple dispute. Respondent comes in and says, I have a $120 million counterclaim. Then SIAC, the president, is called to decide the expedited procedure. What are the considerations there, and how would that work?
Absolutely. So actually, when the president evaluates whether to allow the expedited procedure, it's exactly what it is. It's a proper evaluation. So we don't just go blindly by the fact that the respondent puts in a 50 million counterclaim, where when it's, let's say, potentially seen that it's actually a very inflated counterclaim. So it is a judgment call by the president, and the president does scrutinize the cases that put forward for his decision. And in that particular case, the president has the discretion to actually allow proceedings with the expedited procedure. What must be said, this issue is, we see it not just with the expedited procedure, we actually see it with the normal regular arbitrations when the respondent tries to put in a higher counterclaim so that the cost of the arbitration and the deposits which are collected towards the court are increased, hence creating the burden for the claimant to proceed with the arbitral proceedings. So, it happens notwithstanding expedited procedure.
So would it still remain a hard cap? And I think this is kind of a tricky question, because so if you have that same situation where you have a $100 million plus counterclaim, I think if I'm reading you, what you're driving at is that we have this ability to be able to call for deposits, and particularly separate deposits. I think where the institution runs into issues is assessing the sufficiency or the validity of the claim. It's more assessing the existence of the claim. So I think you as counsel, you running this case, and then you've had lots of situations like this before, then that might be a case where the registrar decides to run separate deposits on the claim and counterclaim. So you can't idly just enter a $120 million claim to just put that in your submissions and then the expedited procedure goes away. I think, explain how that would work on the separate deposits in addition to the counterclaim filing fee.
So basically, as our users would know, that the registrar is the body fixing the deposits towards the cost of arbitration. So, and it's an absolutely discretionary power of the registrar. So the registrar, taking into account the legal and the factual metrics and the amounts put forward by the claimant and by the respondent, can actually fix the deposits at any proportion. So the default position under the SIC rules is that it's a 50-50 split among the parties, meaning that the total estimated cost of arbitration are equally called from both of the parties. And let's say if the respondent has put a counterclaim forward, the respondent would also be expected to put the deposits forward. And if the respondent does not put the deposits forward, the respondent may lose the right to actually proceed with the counterclaim. Whereas in this case, let's say, and not just if the respondent is abusing the process and actually putting a high counterclaim, but let's say validly, the claim is much lower than the counterclaim amount. In that particular case, the registrar may decide that it actually merits to fix separate deposits for the purpose of, fair proceedings. So in that particular case, maybe going by the proportional split between the claim amount and the counterclaim amount, the deposits could reflect the same proportionality.
And this is really where the experience of an institution matters. SIAC has had hundreds and hundreds of these applications for expedited procedure. It's not easy enough to just have the provision. You have to think about all of these different ways that parties might be applying the provisions. One thing that I thought was quite satisfying is in Untitled Working Group 2 that's looking at fast track proceedings, how the experience of SIAC in Singapore particularly was looked at, just because we've had hundreds and hundreds of these applications. We're going to talk with all of the panelists a little bit about the interaction of expedited procedure with some other provisions, but thank you for providing that very good background and how this can be deployed, particularly during the time of COVID-19. Jordi, we've discussed expedited procedure. I think equally important and increasingly relevant is an application for the appointment of an emergency arbitrator. I think SIAC introduced this provision in 2010. I think it's well known to all the users, but can you give us some background on this provision for the appointment of an emergency arbitrator, and any way that COVID-19 has changed the way that the Secretariat handles EA applications? I'm sure that weekends are still taken away processing these, but how is it doing?
Yeah. So, well, I mean, the idea of an emergency arbitrator is simply that if one party before a tribunal has been constituted needs some sort of emergency relief, it can, under our rules, apply for an emergency arbitrator to be appointed and issue the emergency relief needed. So in terms of how we've been processing EA applications, I don't think COVID has changed anything important. I mean, of course, there are some logistical issues that I can discuss a little bit, but the way we handle the application is the same. Obviously, we go through the same steps. Of course, most people involved in the process are likely working from home these days, but so far that hasn't had much of an impact. We've certainly handled many EA applications since COVID and since the circuit breaker. And I think we've been able to do it without any major disruptions to the process, without any disruptions at all, I would say. I mean, there are maybe three things that may have changed slightly because of COVID and the circuit breaker. One is, I mean, it's been already mentioned before. I mean, how the application is sent or served on the other party. I mean, of course, now with movement restrictions, that could be an issue. And of course, given that very tight deadlines for EAs, then that could be more relevant than for just ordinary commencement of the arbitration. Another issue could be how fees and deposits are paid. We've also discussed it before. I mean, we ask parties pay via bank transfer as much as possible because our offices are closed, so it's difficult for us to get the checks if people try to send checks there or show up with a check. So of course, sometimes bank transfers can take a few days to actually, for the money to actually hit our account. So that's something that people need to take into account, because what matters at the end of the day is when we actually get the money for the thing to get started. And maybe a third consideration is that we may be paying more attention to where some of the potential emergency arbitrator candidates are physically located when we decide who to appoint. I mean, of course, if someone is in a jurisdiction with very severe movement restrictions that may cut against choosing them, we also may want to make sure that the person will be able to attend a hearing if for some reason that's needed. So it may make sense for the parties and the EA to be in the same place. But I think that at least based on my experience and what I've heard from others, that's pretty much the extent of the changes that COVID has resulted in.
Yeah, you're absolutely right, and I think the service, because most times under the SIAC rules, the application for emergency interim relief is concurrent or subsequent to the notice of arbitration, but prior to the constitution of the tribunal. But one thing that we make very sure about is that this application for emergency interim relief has been served on the respondent. So if you had a situation because of the disruption to courier service and say a respondent didn't have an email address, would we be making sure that the respondent has been notified? Because we don't allow ex parte proceedings, so it cannot be an ex parte application. The respondent may choose not to participate, but this ties exactly to what Piyush was saying, to make sure that you have all the contact details and you have looked at all of the different means for affecting services. So I think that's an important point. Jordi, one thing I think that you've been leading the discussion on with your keen eye for some of the SIAC provisions is the interaction of the different pre-constitution applications. And the ordering of these is very important. And we can look at this with really any of the provisions. So it's without question that this is concurrent to or subsequent to the notice of arbitration. How would this work if you had, let's use an easy number of 5 contracts, and there was also an application for consolidation, and there was also an application to join an additional party. Let's assume this party is prima facie bound, or let's make it even easier and say that it's a signatory but has not been named in the notice. What is the ordering? How does that work? What is SIAC's experience with this?
So in this scenario that you suggest, this is difficult because it has both the consolidation and joinder. We've certainly dealt with EAs concurrently filed with consolidation and with joinder. So maybe I'll address that first and then discuss the interaction between the joinder and consolidation in a particular case. So if, the easiest case would be if a consolidation application was earlier determined and now we already have a consolidated application, a consolidated arbitration, and then an EA application comes in, then of course that would be the same as if it just one arbitration. A more difficult case is when one party files at the same time a notice with invoking 5 different arbitration agreements and seeks to consolidate. Then I think there are 3 ways that we could deal with that, and I think it's mostly up to the applicant to choose, subject to our ability to do what they want us to do. One way to do it would be to appoint 5 EAs, 1 for each of the arbitrations. That's straightforward. You just treat. I mean, you have to, of course, file 5 EA applications, 1 for each of the arbitrations. Then there may be the possibility of the applicant asking the registrar maybe to waive some of the fees for the deposits, and it will be for the registrar to decide. And another possibility would be to just appoint 1 with respect to 1 of the arbitrations, assuming that the applicant thinks that that will be enough to get the relief that they seek, and then we would just process the application with respect to 1 of the applications, get an emergency arbitrator appointed, and that's it. Then maybe the more difficult option for us would be if they want us to determine consolidation before we deal with the EA application and appoint an EA, because if we want to keep within the tight deadlines of an EA, that's tricky, because for consolidation you would typically it would typically take a few weeks for the parties to comment, for the court to decide the application. So it's not something that we would do within 24 hours. But we have in the past determined consolidation applications in a kind of a very expedited fashion before an EA was decided. So the party confirmed that that's what they wanted to do. We immediately got the court to, well, first we of course asked the parties with a very compressed timeline to comment, and then the court was able to decide very quickly. I think whether we can do it in any given case is very dependent on the facts of a given case, how easy the case for consolidation is. And if it's a tricky consolidation application, it may be more difficult for us to do it. Also depends on whether the respondent is participating or not. So there's no guarantee that it could be done very quickly. Of course, we're still not going to be able to do it within 24 hours. So I think the way we do it is that we first deal with consolidation quickly, and then we deem the EA application to have been filed with respect to the consolidated arbitration, and then we start the clock at that point. And we would certainly appoint an EA within 24 hours of the consolidation decision, and that's what we did in my recent cases.
Yeah, that's what I suppose that's one of the considerations, and there's some tactical choices to make under Rule 6.1. I think the difficult situation is where you have the emergency interim relief using that 5 contract example, where it's really spread across all of the contracts. One of the advantages of the SIAC rules is you can file a single notice, multiple notice, pre-constitution consolidation, post-constitution consolidation. So if it was tied to a single one of those contracts, then you could just make that application in that single contract, or I guess you could make separate applications in a lot of those contracts, because of course we're going to need the other side to comment. But I guess safe to say, in the examples we've been talking about, consolidation, if applied for, is going to need to come first if the relief is spread across all 5 of those contracts. I mean, even though everyone in arbitration is dealing with timing issues, it's still one of the only places in the world where you can make that 1 in the morning Friday night application and still have it dealt with in 24 hours. And I think fair to say that we've seen an increase in parties applying for emergency interim relief. Okay, so that sets the stage nicely on consolidation. Piyush, did you want to jump in and say something?
Yeah, just going back, I mean, I mentioned that the registrar has the time to extend timelines earlier. Now, registrar under 2.6 also has the power to abbreviate timelines. So in a situation like this, where it is appropriate, the registrar could also exercise the discretion and ask for a response which is shorter than the 14-day time period which is given. So I'm just saying that that's possible, especially in the scenario that you described, Kevin.
Exactly right, and that power also exists under expedited procedure. We've talked about this, and we were talking about it before. Say if you were making an application for expedited procedure on the basis of exceptional urgency, the registrar could abbreviate timelines under the rules for the notice, or even that 6-month period for the issuance of the award. Yeah, very good point. Okay, Jordi, that's consolidation. That's multiple contracts. What about a situation which we have had before? Notice of arbitration, claimant, respondent, then in the application for the appointment of emergency arbitrator, there's reliefs claimed against the second respondent. Let's assume a signatory or at least prima facie bound. We raise that up to the claimant, confirm, do they mean to make an application to join this party? How would an application for joinder work?
Yeah, I mean, I think it's the similar approach that we would take. We have done it in the past. We have also address the joinder application first. Of course, that means that we have to give the parties and also the additional non-party that would have to be, that is sought to be joined, we would have to give them the opportunity to comment. But we have done it, and I mean, I'm thinking of one case in which they all consented, and then the court quickly granted the joinder application, and then we moved to the EA application once the other party had already been joined. I think, you know, it all depends on the facts of a given case, how complex the arguments for joinder are, and I mean, how much time the parties need to discuss the issue, and also how urgent the need for emergency relief is. If they really need it within hours or days, then it may not be feasible to do this. If not, then if it's okay to wait for a few days, then I think it would be easier for us to do it. But the thing, I mean, of course, there is no specific provision in the rules for this kind of expedited consideration of joinder or consolidation obligations. So that's entirely, I think, within the registrar's discretion and the court's discretion whether to process them in this expedited fashion.
Yeah, if I could just add in, I guess, with a sub question on this. One interesting element of the SIAC rules, and quite intentionally, is that you don't technically have to make an application for joinder. This is something that could go to jurisdiction. You could have a notice with respondent 1 and respondent 2, and whether the contract is there's been assignment or it's a principal agent relationship. So I'm sure that you've seen cases. So it depends a little bit on how the claimant wants to run the case. You could also make your application. So we're just confirming if you want to get the SIAC court stamp of approval to actually decide on the joinder, but it might be something that goes to jurisdiction. Let's look at jurisdiction. Piyush provided us the background on 28.1, this prima facie standard. So under paragraph 7 of Schedule 1, the emergency arbitrator has the power, all the powers vested in the tribunal, including the authority to rule on his or her own jurisdiction without prejudice to the tribunal's determination. Put a bit differently, what happens if a party says, I didn't sign the contract, I didn't agree to SIAC arbitration, and now there's an application for emergency interim relief against that party? What is the interaction with jurisdiction and an application for emergency interim relief?
Yeah, I mean, the party could, of course, just address its objection to the EA directly, and then the EA would decide whether it's not entirely clear what standard the EA would apply. Some EAs seem to have adopted some sort of prima facie standard for jurisdiction. Some of them just seem to do a jurisdictional analysis, like a regular analysis. That's one option for the EA, as you mentioned, obviously has that power. Then there is also a possibility that the party had already applied to through Rule 28.1, which Piyush mentioned earlier. I haven't seen any situation where we've had pending jurisdictional objection and then an EA application comes in. So I think we'd have to make a decision on a case-by-case basis how we would process both, whether we would try to make a decision on the Rule 28.1 objection before we deal with the EA application. I think it would depend largely on the nature of the objection. I mean, if it's very, very obvious what the outcome would be, then we might want to do that. If it's tricky, then we may just defer it to after the EA application has been processed. Then, of course, there's the possibility of inconsistent decisions from the EA and from the SIAC court on jurisdiction, which raise a whole bunch of issues, I guess. I don't know if we'll get into them. I mean, I have seen in a recent case one example of an EA determining that there was no jurisdiction as to one of the respondents. And then a few weeks later, there was a 28.1 objection from that party which was referred to the court, and the court decided that there was, I mean, the standard for, that the arbitration would be allowed to proceed against that party. So it could be seen as two inconsistencies. I don't think that's the case, though. I mean, of course, the two of them are not necessarily applying the same standards. The EA is free to make a decision on jurisdiction based on the scope of the arbitration agreement, which is not something that the court can do. There's also the question whether the EA's decision was just limited to the EA application and not to the broader arbitration.
I think scope is the perfect example, and I think the sort of safety and comforting language is for the purposes of this application for emergency interim relief. So I've worked with a few emergency arbitrators where we've looked at that language, that I don't have jurisdiction over this second respondent for the purpose of this application for emergency interim relief. That allows the institution to still be effectively making a prima facie competency decision, and then ultimately the tribunal is going to be able to properly hear the parties on jurisdiction. So inconsistent, but I think consistent in how it would actually work, and fairly consistent. Okay, that's tricky. Let's talk about something a bit easier and a bit more fun. So we know that the registrar can abbreviate the 14-day deadline. Does this happen? What is the fastest award that has ever been issued? And let's be fair, we have hundreds or thousands of people online. What is the slowest emergency arbitrator award that's been issued, if you have those stats at the ready?
So, I mean, whether the registrar has abbreviated the deadline, I have not seen that happen. But, I mean, I asked around, and of course, it hasn't happened in my cases. I think it just makes sense for the parties to deal with that directly with the arbitrator, I mean, with the emergency arbitrator.
Agree completely. But by the way, the question is, do you want to prescribe that necessarily, or is this something to put to the emergency arbitrator that this is very urgent? We need an award by day.
No. I mean, of course, I think the parties are free to try to get the registrar to abbreviate the limit so that the arbitrator has no discretion. I have not seen that happen since we have this 14-day deadline in our rules. I think it's it's unlikely that the registrar would do that, in my opinion. I think, as we were saying, it would be left to the EA to determine whether there is this need for an even faster award. What we have seen is the registrar extending the deadline for a few days. So in terms of faster and slower, I wasn't able to get hard figures. I mean, what I've seen is awards issued within 1 week of constitution of appointment of the EA. So I think that would be I doubt that there's, I mean, of course, sometimes the EAs issue some preliminary orders very, shortly after they are appointed, just to make sure that they have time to actually get to the merits. So I guess it could be done in a few hours in that sense, but it's not an award, not the EA award that we would get at the end of the process. Yeah. And on the slow side, I mean, what I've seen, maybe some of the others on the panel have had experience with slower. I mean, I've seen extensions of roughly 1 week granted since we have these 14 days. I don't know what the numbers were before we had this hard deadline, but I haven't seen in my quick review of our cases a lot longer than that. And usually it's because the parties themselves have requested extensions to file their submissions. It's not just because the EA has been slacking off. It's just
yeah. Maybe I could try a parsing of your words, because I've effectively used the lawyer's maxim that I only ask questions that I hopefully already know the answer to. I think the reality is that the emergency arbitrator award is going to be as fast as it needs to be, as long as the other side is still provided with due process and a right to be heard. So the ones that have been slow, in our observation, it's because now that you might have an interim order and there's not the same urgency, and the parties actually want to have multiple submissions on costs. What I can say with great confidence to any of the attendees, there's no case where an emergency arbitrator is just sitting with an award and drafting an award for days. These timelines are moving incredibly fast. And Jordi, if you could, maybe you could, you did one recently, touch on the scrutiny process for an emergency arbitrator order and award. And I think that's a very important feature for SIAC. It's not just having these emergency arbitrator provisions, because it might not be a status quo order. It's a mandatory order, and these are important to look at. What is the timing for the scrutiny process, and how does that work? How's your experience been on that?
Yeah, I mean, we have to scrutinize in a much shorter.
You don't sleep. No sleep. You get the award at 10 p.m. and
what we try to do is get the A to give us a heads up. That's what I try to do on when they expect us to get the draft, so we can plan and clear our schedule for that morning or afternoon, and also let you know so that you know that it's coming and that we'll need to scrutinize it immediately, because that's what we do. Basically, as soon as we get it, we scrutinize it. We can't just leave it sitting there for a few days generally. So for my latest one, they actually, the arbitrator in the merits hearing, I was there, and he asked us how much time, whether we could do it in 1 business day. So if he got it to us in the morning, we could get it to him by close of business. So I didn't commit to that. I said that we would do our best, but we actually did manage to do it. It was.
So same answer again, as fast as it needs to be, as fast as the emergency arbitrator needs to be, to the extent that we can. Okay, that's a very good background. I think what's been interesting is that we are seeing an increase in these applications for emergency interim relief, but because we're in the COVID-19 pandemic, how do you have hearings on these applications? I would like to turn it over to Shahat. Shahat, of course, has been working very closely on a bunch of our electronic case management processes, has been participating in working groups on virtual hearings, so really knows the space. Shahat, let's keep it to pre-constitution applications, and tell me about emergency arbitrators and virtual hearings. Are they able to? What are some of the different considerations? Do the rules allow emergency arbitrators to have these?
Sure. Thank you, Kevin. As you know, Rule 19 of the SIAC rules provide a very broad discretion to the tribunal to conduct the proceedings in the way they deem fit, of course, after having consulted with the parties. However, interestingly, in the case of EAs, the EAs have 3 broad modes of conducting such proceedings. First, of course, is in-person hearing. They could physically convene at a particular place and hold the hearing. The second is a virtual hearing, which is video conferencing. which is also provided for under our rules. And the third also is that the ES can hold proceedings on the basis of written submissions of the parties. As you mentioned, I think one of the most important considerations for conducting a EA hearing virtually is ensuring that parties have been given a reasonable opportunity to be heard. So due process concerns is something that the tribunal should bear in mind while deciding to hold a EA hearing virtually. So this question may entail further inquiries, such as whether respondents or the claimants or any other relevant parties have access to technology so that they are able to participate in the virtual hearing. I actually spoke to some of SIAC's tribunals who have conducted virtual hearings very recently, and I sort of made a short list of the feedback that I got from them. And I'll quickly go through the feedback that I got from the SIAC tribunals. First, as I already mentioned, a very important thing to consider and bear in mind is the parties' ability to present their case properly. Second is parties' time zone. So, I mean, this would also perhaps tie into the due process aspect. And because in international arbitration, you can have parties from a variety of jurisdictions. So the tribunal may want to also evaluate where the parties are located. Also, data privacy concerns. Some jurisdictions have strict laws about how the data flows across borders. So tribunals may want to also keep that in mind. Further, length of the oral hearing. I mean, it is not necessary for the tribunals to replicate the physical hearing on an online platform. So from that perspective, they can also look at reducing the length of the hearing. Also, another factor is the platform to be used. So different tribunals have different preferences. So the parties, tribunals may also wish to, ask parties to sort of make comments in relation to which platform they are comfortable using. The speaking etiquette and this order of speaking. I think perhaps this is a very important consideration because in a virtual setup, it is very easy for participants to speak over one another. And that perhaps could create issues with things like transcriptions. So it is very important for tribunals to understand and also implement a speaking etiquette. Also, another thing that the tribunals and the parties could bear in mind is the format of evidence. In fact, one of the SIAC EAs indicated that he insists that parties file their electronic bundles in a specific format so that he is able to very quickly navigate through the documents when they're conducting the virtual hearing. Also, three other things that I have on the list is the need to sort of consider whether or not there is any need for third-party vendors. So whether you require translation services, transcription services, and so on. Also, you could consider when you will take a break and how you will request for a recess during the virtual hearing. And finally, because virtual hearings could be easily recorded, tribunals could also sort of keep that in mind, whether they'd like to record the entire virtual hearing in addition to providing for transcription services. So these are some of the things that the tribunals and the parties may keep in mind. And I think I would just add one more point, which I have not mentioned in my list, but I do remember, discussing this with the tribunal. So the tribunal explained to me that having 4 screens in an EA setup is very important. So one screen perhaps for following what is happening in the room, one screen for looking at the witnesses, another screen for just navigating through different documents, and the fourth screen for other editing, for example, purposes or other search functions. So perhaps, yeah. Yeah, so I mean, this is again, I mean, this is a subjective preference of the tribunal, not necessary in every case. So these are some of the factors that tribunals may bear in mind while opting for an virtual hearing, specifically with regard to any pre-constitution application, for example.
I think it's really valuable how you've been able to survey all of these emergency arbitrators, because in addition to doing a lot of the emergency arbitration straight away, SIAC is also getting early experience in these emergency arbitrator hearings. I've walked into work at least a couple times when we were back in the office where there was already emergency arbitrations ongoing, where we had SIAC counsel in front of the screen. So I think that we're able to really draw upon this collective experience from all the SIAC emergency arbitrators. And now we just maybe need to give it a good name. It can be the SIAC checklist, or perhaps the Chahat checklist on the considerations for virtual hearings, and particularly in the context of an emergency arbitration. We have a question from one of the attendees that happens to be a very experienced senior arbitrator that has sat quite frequently as an emergency arbitrator. The question put to you, Chahat, is that if one party insists on a physical hearing, not documents only, can it be assumed a virtual hearing will suffice in COVID time? If you could sort of answer that generally, whether emergency arbitration or otherwise.
Sure. I mean, as I also mentioned, SIAC rules specifically provide for EAs to conduct hearings by way of video conference. So in a hypothetical situation where one of the parties insists that they want a hearing and they do not want to proceed on the basis of documents only, the EA can rely on that specific provision. To be exact, it is Schedule 1, paragraph 7 and 8 of the SIAC Rules 2016, and perhaps organize a video conference. So that could be a short response to that question.
Yeah, and to the extent that you can, what about the different platforms that are being used? So if I'm in a party in an SIAC arbitration, I filed an application for emergency interim relief. We have the emergency arbitrator appointed. What is the process for deciding on the platforms? And maybe if you could speak a bit on the arrangement between Singapore, London, and Toronto as well, that might make this even easier going forward.
Sure. I think one of the benefits of SIAC rules is that we don't have a straitjacket formula for all arbitrations. So we are cognizant that different arbitrations may require different solutions or different procedures. So parties and in the context of EAs have used a variety of different platforms. They have used the Maxwell Chambers ADR hearing solutions. They have also used Zoom and Microsoft Teams to conduct hearings virtually. So broadly, these are the platforms that have been used by tribunals to conduct emergency arbitrator hearings. And also in other cases, parties have agreed to sort of dispense with virtual hearing or any other physical hearing altogether. And the tribunal has decided on the basis of written submissions of the parties. Maxwell Chambers in Singapore, of course, is at the forefront of developing and offering different solutions to users of international arbitration. I understand that they have a tie-up with Blue Jeans as well as Zoom to conduct hearings remotely. And recently, as you mentioned, they had tie-up with different hearing centers in Canada and also in London, so that they can share their knowledge, expertise, and know-how, and essentially facilitate international arbitration virtually in a seamless way.
Makes sense. One of the things that we've been trying to do with these sessions is make it practical. I think everybody in arbitration now knows virtual hearings, but there's still lots of users, lots of counsel, lots of arbitrators that have not yet, because of whatever circumstances, conducted a virtual hearing. One advantage that we have at SIAC is that we often tend to be the first mover, and we have data. So we were talking about some of the different cases where there has been a virtual hearing used in the context of an emergency arbitration. Could you walk us through the timeline and the chronology with that one case that we were discussing on how this actually worked in practice? So let's take it out of the coffee house, the aspirational talk on, we know that we need to have virtual hearings. How does it actually work?
Sure. So I actually made detailed notes for this particular emergency arbitrator hearing, which was held virtually to ensure that we do not miss out on any key procedural step. So the one that I'd like to discuss was actually commenced in the last week of April, so it's very recent. The emergency arbitrator, as is required under the SIAC rules, was appointed within the 24-hour time frame. Right after the emergency arbitrator was appointed, the EA scheduled a video case management conference for the same day. And this case management conference was conducted on the Microsoft Teams platform. This was suggested by the claimant and then agreed by the parties, and the tribunal also agreed to conduct the preliminary hearing or case management conference on the Microsoft Teams platform. Also important to mention is that both parties were represented by counsel, and both counsel and parties were based in the common time zone, so they did not have any difficult logistics in terms of different time zones. Also, once the case management conference was conducted, the EA, among other things, directed the parties to make all the submissions electronically. So in other words, it was a completely paperless arbitration. Subsequently, the EA requested the parties to liaise with Maxwell Chambers ADR Hearing Solutions. This was the platform used in this case, and also sort of arrange for a real-time transcription service. The parties agreed, and they contacted Maxwell Chambers ADR. A day before the hearing, the EA and the parties, along with the Max Chambers service provider, participated in a dry run or a test call. I mean, we have heard in various other webinars that dry run is so important, and actually this proved to be extremely important in this case as well. And the tribunal sort of tested, among other things, the chat functions, the breakout from room features, the communication protocols, the parties' order of speaking, and also arrange for any backup plans in case there were some issues with the virtual hearing on the day. So following the dry run, the main hearing took place in the context of the EA proceeding, and the arbitrator managed to conduct a full day of hearing. So it was conducted between 9:30 a.m. Singapore time till 5 p.m. Singapore time. And this video conference was attended by the EA, 9 party representatives, which were consisting of lawyers, the service provider's moderator, and a transcriber. And in the course of the hearing, different parties relied on different electronic bundles and so on. So that was all seamless. So the overall feedback was good. And subsequently, after the hearing was over, the draft award or the decision was submitted to SIAC within the 14-day time frame as required under the SIAC rules, and we scrutinized, and the award was eventually issued within that 14-day deadline as well. So this is sort of a recent experience of conducting emergency arbitration in a virtual platform.
Would you say that hearings on applications for emergency interim relief, and not just because we have the express reference and contemplation of hearings by video, are even more amenable to virtual hearings? I think that the reviews are a bit different. Some people are saying that they need to see the whites of the witnesses' eyes, and you hear from some arbitrators where they say, I'm actually even more easily able to assess witness credibility because you have a camera very close to someone's face. Do you think that emergency arbitrations being conducted by virtual hearings is something that we're going to see even once we're back to the previous normal?
Absolutely. I think if applied in appropriate circumstances, virtual hearings perhaps could be useful and result in saving of time and cost. And just moving beyond the theme of today's topic, I mean, since you mentioned how parties are I mean, the impression in the community is that mostly it's only meant for plain vanilla arbitrations. I mean, even previously, very recently, another SIAC tribunal conducted witness conferencing virtually. So that is something that we're also seeing. But of course, for mega disputes, which are very high stake and other complex disputes, it may not be very appropriate or suitable. So I think it is a call that the tribunal would have to make on a case-by-case basis after inviting party submissions and views.
Yeah, exactly right. Well, I noticed that our time is up. I want to thank Alona, Piyush, Jordi, and Shahad. Thank you very much for your contributions. We had lots and lots of questions today that we weren't quite able to get to, but we do have this live chat feature. Obviously, feel free to join us on the live chat. We would be happy to answer them there, or email me or any of the counsel. We're happy to continue this discussion. And to all of our users, thank you very much for your attendance. Thank you for helping us advance the dialogue, not just on COVID-19, but also on arbitration generally. We really appreciate your attendance. Thank you and good evening.
Thank you.
Thank you.